Here we go. Good afternoon, everyone, and thanks for zooming in for our second day of the 5th annual ICWA Institute. And I'm just so happy that you're all here and you're all sitting in the comfort of your home and you're in for a real treat today. As you know, I'm Laura Lee Bentel, and I'm from the Cherokee Band of the Eastern Band of the Cherokee Nation. And we're going to be talking about the law today. And the two ladies that are going to be sharing with you have great knowledge, great wisdom, and are very relational. So I'm really grateful to introduce Lori Irwin and Kaycee Looney. Take it away, girls.
Thank you, Laura Lee. Hello, everyone. My name is Kaycee Looney. I have worked in the child advocacy world for 11 years, and I helped start this institute. So I'm really excited that you're all here to join us for our 5th one. And thank you all for coming and joining us.
And I'm Lori Irwin. I'm one of the attorneys at the King County CASA program. I've been with CASA pretty much my entire life, and I am really excited that this is our 5th conference. It's just as hard to believe that we've been able to put this together, and we were able to roll with the COVID punches. This is our 2nd Zoom conference, and we welcome you and look forward to working with you today. So we're going to start off with a video, and I know you all are very kind to presenters because of course there are always glitches. So even though we've done this more than once, I hope it goes well. So I'm going to share my screen and we'll keep our fingers crossed, right?
My name's Fawn Sharp. I'm president of the Cornell Indian Nation. When they first came to our home, I started to see right away, this is a really good constellation of kids. My children are 3rd generation foster care, Native American Indian children. Their grandmother grew up as a child in Alaska. She was taken out, placed into a foster home in Oregon. Her daughter ended up in foster care. And then by the time she was 21, she had 4 children, 3 of mine. And that could all be traced back to a federal policy designed to break up Indian children. Child Welfare Act is designed to keep Indian children whole. When states fail to comply with ICWA, it creates so many problems, not only for the families, but ultimately the children. Our son really started wanting a sibling. He said, "Mom, I want you to have a baby now," as though I could just deliver a sibling for him. My husband and I really started to have a serious conversation about adoption. The social worker called us and had identified 3 Native children. We were told we were the only Native family in the mix. So under ICWA, we should be the family selected. I put a lot of time, energy, effort into a remodel of the house, adding 2 rooms, bought an SUV. I had a text message from the social worker, "Please call me." She said, "Fawn, I'm so sorry, but the selection committee picked another family." I thought to myself, I'm just going to simply ask for an administrative review just to ensure the Indian Child Welfare Act was complied with. I did a little bit of research, and I came across a GAO report that highlighted the failure of states to implement ICWA the way it was designed and intended. Sure enough, about a month later, we got another letter that said, we did find they failed to follow the Indian Child Welfare Act. However, there's another family that we're going to be placing these children with. We let a good 2 months go by just to sort of, I guess, mourn that loss. In February of that following year, I received a call from a social worker. She said, "Do you remember the 3 children that you had gone through our process with last year? We placed them in a home and it didn't work out." I just thought, how can this happen? How can this happen? They found that one of the members in the family had a criminal history. If they would have found during the review process that, gee, there's a disqualifying factor, they wouldn't have been even sent to that home. So it was about a 2.5-year process of 2 different appeals and the back and forths and being placed in a home only for 4 months. When they first came to our home, the kids told me that they had gone through some pretty terrible things in that home, and we suspect they had gone through some unspeakable things. It crushes my heart to think that had Oregon followed the Indian Child Welfare Act, the children would not have been placed in a home where those things happened to them. It's going to be with them for the rest of their life. Any child that goes through foster care and they have that disconnection from a nuclear family, it's compounded when that removal is not only from your nuclear family, but your nation, your citizenry. It is in that child's best interest to maintain their identity and who they are as a person. You could just look to the historical trauma that tribes face today. We were taken away from our communities. We were put in boarding schools. Our languages were lost. Our cultures were lost, and our traditions. And you find that young people today, they have that cultural connection. They're becoming stronger. And each generation, we're building and improving and healing from past trauma.
Thank you so much, Ryan. So what I want to emphasize is where Fawn left off, and she talked about the systemic failure of the courts and the system to follow ICWA. And that's why we're here, because we want to talk to you about the law as it exists and what's necessary. And if you were able to participate with Miss Bentel yesterday, you were exposed to the beginning and the underpinnings of ICWA. And Kaycee and I are here to talk to you about the structure that exists through the law. One of the things I wanted to point out is if you look behind me, I don't know if you saw that in the video, but I believe that this is a little screenshot from Fawn's place there out on the peninsula. And I have this as my background because it helps me remember that there are beautiful wild places, and we need to have those places for kids to be free and families to experience a comfortable and relaxing atmosphere. And it helps me relax, as opposed to having my office background, which is very sterile. So I want to take us through, we're going to start with a presentation with PowerPoints, and we'll have a chance at the end for questions. And you can also put questions in the chat. We'll have some help from some of our other ICWA Institute members to try to answer those as well as we can. I'm going to try another screen share. We'll see if this goes a little bit better. And this one doesn't have sound. Can you all see that? Welcome to ICWA. There we go. Thank you. So if you want to look at more of these videos like the one that was done by Fawn, you can go to the National Indian Child Welfare Association, NICWA. Just Google that and type in videos. And there are a number of really interesting and beautifully done videos that talk about the Indian Child Welfare Act and the people that are impacted by it. So one of the things I wanted to do was pay tribute to Roxanne Finney, who has recently retired from the Department of Children and Family Services, where she started off as a social worker. I worked with her years ago, and then she was the Indian Child Welfare Program Manager. She had a big impact across the state and put together the manual that partially upon which this PowerPoint presentation was built. Things to remember about ICWA, just to keep in your head. You know, ICWA only applies in state courts. It doesn't apply in tribal court. It applies based on political affiliation, so citizenship. Keep in mind that members of tribes are citizens in those tribes, just as much as Canadians are citizens of Canada, Mexicans are citizens of Mexico, French are citizens of France, and that sometimes people have dual citizenship. So remember that it's a political affiliation. And much like any other political affiliation, the tribe gets to decide on its membership, just like the US decides who's a citizen, or Mexico, France, Spain, any of those countries. The tribe gets to decide on how the rules are applied. They get to make a decision about what their placement preferences are. One tribe may prefer to place with an uncle on the mother's side. Another tribe may prefer to place with the grandparents. There may be cultural expectations that we know nothing about. And as child advocates, it's our role to ask those questions. And the tribe can also decide whether to take jurisdiction. Some tribes have quite advanced tribal courts and tribal court systems that have specialized court days that address child welfare issues. In those cases, sometimes the tribes decide that they want to take jurisdiction of a case. If they want to take jurisdiction, you can pretty much assume that the child and the case will go before the tribal court. There are a number of requirements and some hoops to jump through, but by and large, I think in Washington state, if the tribe is seeking jurisdiction, the case is going to go to that tribal court. However, in Washington and the cases that we deal with internationally, many tribes do not have the resources to have a tribal court, and they'll participate in our local state court. The other thing I want to remind you about is advocates need to be proactive. So one of those things is asking everyone you talk to, is there tribal heritage? Are these children Native American? Is there Native American heritage? Is there Alaskan Native heritage? And keep asking, not just once, but continually to check in, because people may remember something. They may have had a conversation with an elder or a relative and been reminded that, oh yeah, there is some tribal connection. And that's one of the things that CASAs and child advocates are required to report in the court reports. So the Indian Child Welfare Act, it was put in place in 1978. That was after a very long and complicated lobbying effort before the United States Congress to have in place this protection that would protect Indian children and their families from being taken away from their tribes and their culture. So many treaties, many statutes, throughout history, there have been laws that have impacted the relationship between the United States and tribes, usually, and I would say almost always, to the detriment of the tribes. The whole underpinning of ICWA is that it is to protect the best interests of Indian children and to promote the stability and security of Indian tribes and family. Imagine if your family or your extended family group was unable to keep the children in their homes or in their community, and everyone was taken away. It wouldn't be long before that community disintegrated. There wouldn't be no next generation to teach or to raise or to be there to take over responsibilities. And that's the same thing for tribes. It is extremely important that children remain with their communities and their families. So here it said in the findings, there is no resource that is more vital to the continued existence and integrity of Indian tribes than their children. So we have these public laws. Reason for that, you can see here, and you probably have been exposed to some of this, is that there was such a high degree of removal of Indian children from their families. And I hate to say it, but I think that if you look at the disproportionality statistics in Washington state and other states, there is still a high proportion of Indian children that are removed from their families, much higher than in any other ethnic group, much higher than would be explained by simply poverty alone. And it reminds you again that ICWA is based on citizenship, that political affiliation. Here's a disproportionality map. We can look here at Washington. You go down to the key. This is the highest at like 4 times the average of other children for the rate of a Native American removed to foster care. Same in Montana, Nebraska, Minnesota, Iowa. High percentage of Indian communities and high percentages of removal. So some of the requirements for states under ICWA, if you are reading through the Indian Child Welfare Act, which you can find in 25 USC 1901 through something, you'll find in there that one of the major requirements right at the beginning is that tribes be notified immediately if there's an issue related to a child, if a child is picked up and taken into custody. There are official notification forms. The Bureau of Indian Affairs keeps a list of registered agents for the tribe. It's only updated annually, so it can get out of date, but there are real specific things that that DCYF is supposed to do if they pick up an Indian child. So because the tribes are notified, they also need to have the opportunity to intervene and be a party to the case. So just with a raise of hands or thumbs, how many of you have worked on an ICWA case or a case that has maybe tribal affiliations? Seeing a few hands here. Thank you. So, you know, tribes can participate in cases in all different ways. Sometimes they intervene and they have an attorney that's represented them who files motions and does all of the other legal stuff like you'd see on Law and Order. They file motions, they argue, they set hearings, they appear in trials and do the direct and cross-examination. And sometimes you have tribes that participate in cases by being available to call in for hearings, and they don't have a capacity to do very much more than that. That may be a tribe that has limited economic resources, and it might also be a small tribe that has one person who is covering all of the children that have been spread across the United States in the diaspora, and they are sitting there in their house or their office responding to calls and being on hearings for hours every day, and that is the capacity that tribe has. Tribes can also ask for, as I mentioned earlier, that jurisdiction be transferred to tribal court, in which case we will wish them well. In King County, that would most often happen. Sometimes that will happen with the Puyallup tribe. Will seek transfer jurisdiction. Sometimes Tulalip will do that. But the local tribes that have child welfare courts may sometimes ask for transfer of jurisdiction. So the other thing the other key words for you to remember is that the department needs to make active efforts to provide remedial and rehabilitative services both before and after placement occurs. Unless it's an emergency, unless the placement is due to some catastrophic event, whatever that might be, the department, if they get a complaint, a CPS report about a child, is supposed to investigate and then offer services to all families, but particularly to Native American families, to offer these services to help them remedy the issues that make the situation unsafe for the child. If a child's removed, there are very specific placement preferences for Indian child. If you remember at the beginning, I mentioned that the tribes get to decide on their placement preferences. Well, the law in Washington under the Washington Indian Child Welfare Act has real specific criteria too. And so if a child can't be placed with the parent then, or a parent, doesn't matter if the parent's the Indian parent or a non-Indian parent, but if the child cannot be safely placed with a parent, then they need to go to a relative. And if they can't go to a relative, and it's not specific what degree of relative, but if they can't go to a relative, then they need to go to another tribal member. And it works down. The very last option is supposed to be a non-native foster home run by an agent, a non-native agency, which is what most of our foster homes are. And the other thing that you'll learn as you work on an Indian Child Welfare Act case is that there's a higher legal standard. I talk about active efforts. Active efforts is like up here, and reasonable efforts is down here, and active efforts is like going the extra mile to make sure that the families can access services, to make sure that they can have contact with the children and parents, to make sure that referrals are in and services are provided in an understandable manner, to make sure that parents can get to the places that they need to be. And then finally, for placement and for termination, there needs to be a qualified expert witness that testifies in support of the placement. So this could be a member of the tribe that is designated by the tribe. It could be a qualified expert witness that is designated outside of the tribe. It cannot be the social worker or the social worker's supervisor that's assigned to the case. As you can imagine, that's going to be a conflict. So there should be somebody that looks over the case with a little bit of distance. More recently, I think in the last couple of years, we've been having contractors that provide the qualified expert witness testimony. And I know you probably have heard of a couple of their names, but Ms. Bentel has recently retired and is a qualified expert witness. And there are a number of others in the state of Washington or nearby that help out. Here's the map of Washington state tribes. And I hope you can look at that and just revel in the richness that we have in our area of culture. You can go from the Makah at the very, very tip out here, the westernmost part of the United States, over to Colville and Kalispell, from a rainforest over here to an inland plateau and desert environment. Very different traditions, very different practices, and so much interesting cultural diversity in our area from all of these tribal entities. One of the things that I would encourage you to do is to pick a tribe, look them up on the internet. Many of them have very interesting websites that talk about their history, their culture, the programs that they're working on. Over in Kalispell, you may have something where they talk about their forestry practices and their land conservation. In Spokane and Colville, you may be looking at different habitat restorations. Down on Yakima, we'll have different things. Up in Lummi Island, you may have interesting things about the culture of the inland Salish Sea. It's just fascinating, and I would encourage you all to do some more work on that. So now I think I'm going to turn it over to Kaycee to talk about Washington laws. And thank you for your patience.
Thanks, Lori. Okay, so Lori gave us a good overview. So now we're just going to go into depth a little bit on these pieces that will be important to keep in mind as you're advocating for kids who fall under the Indian Child Welfare Act. So again, remember that our Washington state ICWA applies only in state courts. Tribal courts can choose to take jurisdiction. So they apply to dependency and termination of parental rights, which most of you are familiar with. They also apply to those dependency guardianships that can be put into place in our dependency courts, as well as the minor guardianships that are now in family court that took the place of the 2610 third-party custody, and also adoption proceedings. You got me, Lori? All right. So our legislature's intent in enacting our own Washington ICWA, in addition to the federal ICWA, was to protect those essential tribal relations and the best interests of Indian children. I just want to pause real quick to say we're using the word Indian because that's the legal term that's used. Do be aware when you're working with families that that may not be the term they prefer to call themselves, and to follow their lead on that and to ask questions. Many families who have Native American or Alaska Native ancestry are choosing to use the term Indigenous at this time. Some are not. So just keep that in mind. So we want to look at, as Lori mentioned, they should be in the department trying not to remove a child, but when that out-of-home placement does need to happen for a child, we want to make sure that the state is committed to a placement that reflects and honors that child's unique values and tribal culture, as well as their citizenship or potential citizenship in a tribe. So some of you may or may not have heard about INRAE-ZJG. So talking about verifying Indian status has gotten a little different in the last year here in Washington State due to a Supreme Court case that came out last summer, I believe. So this case talks about a reason to know if any participant in those proceedings indicates that there may be tribal heritage for that child or that family. So that includes a guardian ad litem who's been appointed or a child advocate who's been appointed to the case. And as Lori mentioned earlier, your role is to make those inquiries and to continue to make those inquiries as the case moves forward. So you may have a case in the beginning where there is no indication there's a reason to know, and that can change. So continue to make those inquiries as you go forward. After we have that reason to know, then there has to be that inquiry sent out to that tribe, band, nation, and also the Federal Bureau of Indian Affairs to verify whether or not that family and child is able to be enrolled and whether ICWA applies to them. There's also a family ancestry chart that should be filled out by family members and given to the social worker so that they can continue to investigate. And we want to make sure that we are continuing that ongoing investigation that's required of a guardian ad litem and child advocate through our laws.
One of the things that I would encourage everyone to do when they start a case is to start their own family ancestry chart, because sometimes trying to figure out who the aunts and uncles and cousins are and how they all relate can be a challenging, knotty issue. And I found that it's really helpful to have that information later on when you're trying to explain to the court why you're recommending a placement with this particular relative.
That's a great point, Lori. Okay, now we're going to talk again about that placement priority. So when we're looking at placement for Native American or Alaskan Native children who fall under ICWA, we're looking at first keeping them with a parent or parents. We can't do that. We're looking at family and extended family. And as Lori said, that could be a very broad range of people. And so we want to make sure that we're making that placement as closely connected to that child's citizenship in the tribe and their culture as possible. If that's not possible, we're looking at a tribal foster home that's licensed and approved either by that child's tribe, or potentially the next one would be by another tribe that is local. But if the child is living in Washington, but their tribe is located in Oklahoma, as the Cherokee Nation is, there's a lot of kids who come through Washington courts from tribes that aren't located here. So we want to look at those connections as well. So we would look at that type of a foster home or one of our licensed foster homes, and then another tribe approved institution. So we want to make sure we're keeping a connection as much as possible for those kids. When we're looking at a place where a child is not going to be able to return to a parent and we're looking at adoption, we have another hierarchy of placement preferences. So again, we're looking at member of the extended family. And as Lori mentioned earlier, that isn't necessarily a family who has Native heritage. There could be a family member who has Native heritage that is not able to take placement, and a family who does not have Native heritage can. So we're still looking at connecting that child to their family first, and as well as their tribe. So if that is not possible, we're looking at another member of that child's tribe or an adoptive placement that is under the state law. The preferences are given in the absence of good cause to another Indian family, so a different tribe. Again, we have kids who are in Washington where their tribe is not local, and there may be a child who's Cherokee Nation and there's a Tulalip tribal family who can adopt them when there's no other family member of their own or tribal member of their own who can take them. One thing to remember there as well is that the tribe can also change those placement preference hierarchies and how they look. So we want to make sure that we keep that in mind as well. This list may not look the same for every tribe. And qualified Indian expert witness, we're looking at the qualified expert witness under ICWA is required whenever an Indian child is placed out of home, and we're looking at termination of parental rights. So that expert is an expert on that child's tribe. They can be recognized in expertise in their child raising standards, looking at that tribe or community. In cases where a child's direct tribal member is not available, they'll look for another qualified expert witness to talk about that tribe's practices. And as Lori mentioned earlier, that qualified Indian expert witness cannot be the social worker or their supervisor, even if you are in a county where your social worker who does all the ICWA cases, there's just one person, they do all those cases. Even if they are a tribal member, they still cannot be a qualified expert witness. So just remember that it has to be a person outside of the department. They have to have expertise. And when there's that reason to know standard, the department should be looking for a qualified expert witness early on in the case.
So back to me. I really want to encourage everyone. I was thinking about that last slide about the QEW. You think about these things that you hear that are in the Indian Child Welfare Act, and they're here because there were huge abuses of these issues. So something that seems as simple as avoiding the bias that would come with someone carrying a case and then being also the expert on the case, it may seem obvious to us looking at it that of course we should have somebody unbiased look at this and served as a qualified expert, but that wasn't always the case. And so many areas of the Indian Child Welfare Act and the Washington Indian Child Welfare Act are specifically there because of historical abuses. So I want to talk a little bit more detail about a tribal involvement in dependency proceedings. So like I said before, the tribe can take jurisdiction and then they are going to assume responsibility for the legal case. My experience is often the tribe will wait to take jurisdiction until dependency has been established in state court, and there's sort of like a straight across transfer. You know, if King County was transferring to Yakima, Yakima wouldn't want it until dependency is established, because that's the hard legal standard stuff that might involve a trial. And I can understand why, you know, the Tulalip or the Puyallup tribe might not want to take jurisdiction until that legal work had been done as well. You know, that happens occasionally, and you know, sometimes there may be a situation where a child is born and or is living off the reservation, and a dependency is filed, and the tribe can find out about it kind of late. You know, maybe notice was provided, but somehow that child slipped through the tribal's administration cracks, and you might have a situation where a tribe comes in later in the game and moves to take jurisdiction, or particularly when there's issues about permanent planning and the tribe is adamantly opposed to termination, a tribe may seek to take jurisdiction. And more often, as I mentioned before, the tribe's going to intervene as a legal party, and that can take many forms. I would encourage you to welcome the tribes, make sure that they get your reports, your child advocate reports that you write, send them out, you know, a week in advance so they have time to review them before the hearing. When you go to court, if you can have, or, you know, even if you're going to court via Zoom like this, you know, have the contact information for the tribe. So if for some reason they're not on the Zoom call or they're not in the courtroom, they can be called on the phone to get them so that they can participate. There are all sorts of reasons why it may be hard to track court hearings. And as you know, we often call our office to make sure that we know which day the court hearing's on. So the tribe, if they're just relying on themselves, they can miscalendar things as well. So as a child advocate, I'd encourage you all to make sure you have that information. And when you send your report, just let them know the contact information for the court and the Zoom link if you're using Zoom, or the address and the phone numbers to call and the time of the hearing, so that the tribal representative can participate. Same for meetings. Show of hands here. How many of you have been to, let's just say this week, to a shared planning or family team decision meeting this week? Anybody? Okay, well, I have had like 5 scheduled so far this week. So, and I take mostly ICWA cases. So as the child advocate, the other thing you can do is when you get those notices, check to see if the tribe's included and make sure that they're included on those notices so they can participate as well. It's really valuable input to have the tribe participating in every meeting and providing input, providing the resources for relatives and placement and guidance. And that as an advocate is something that you can do. And then, I've had situations that have been really complicated where I know that the child advocate and I and the child or the advocate supervisor, we don't have a clue about what all the connections are in the tribe and the community that are influencing what's going on. And I've been very blessed to be able to work with a tribal representative who felt was comfortable enough to kind of explain some of the historical things, because, if the people that you're dealing with all grew up together and they've known each other since they were babies, and they have relationships and interactions and long-term familial relationships, coming in as an outsider, we'll never know what is influencing all of this, and we'll just be in the dark. So I would encourage you to consult with a tribal representative and find out if they can help you understand the nuances of what is going on when things just don't seem to be making sense. So one of the first things the court needs to decide, and I alluded to this a little bit earlier, is like, who has jurisdiction? If a child resides on tribal lands, on a reservation, the tribe has jurisdiction. I mean, so if a baby is born like in Seattle at Swedish Medical Center, but the baby's parents reside on Muckleshoot tribal land or Puyallup or Tulalip or something, that child is domiciled on that tribal land, and the jurisdiction is there with the tribe. So that in that situation, the tribe has jurisdiction. And when I mentioned before about the tribe seeking transfer of jurisdiction, only the parents can object to that transfer, mom or dad, not the grandparents, not extended family, certainly not the foster parents, not the child advocate. It can be the parent, mother, or father that can object. And otherwise you have to provide good cause. And I have to tell you that with the regulations that are in effect right now, good cause is really, 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 really hard to establish. And I would advise you to consult with your program leadership before you consider going down that route. In fact, I haven't, I don't think I've opposed a transfer of jurisdiction in a really long time, both because the law does not support it and because I think I've had a real change in perspective. So one thing down here, and you'll find that in the Washington Administrative Code, is attachment to a care provider is not good cause to prevent transfer to the tribe. this is just so hard. I think one of the values we have as child advocates is that kids should be in placements and they shouldn't be moved. I mean, if we can find a placement that's meeting their needs, that is loving and nurturing and supporting that child, well, that the last thing we want to do is uproot that child and take him or her out and put them in an unknown situation. But, when we're dealing with Indian children and the Indian Child Welfare Act, that attachment to a care provider is a positive, is something to be honored and respected and appreciated. But the underlying focus is on sending Indian children back to their family, back to their culture, and to their nation, to the care of their people. So finding good cause to oppose that transfer is really difficult, and for good reason, because the Indian Child Welfare Act is there to support and reunification with families. So it's been very hard in my experience for care providers, and really challenging. Sometimes, even if a case is transferred to a tribe, the tribe may decide to maintain the placement with those care providers, the licensed placement. I don't know how they do it, but sometimes they decide that that's really what they want to do. They want that child to be in the care of that particular home, but they don't want the state to pursue a termination of parental rights, and they want more time. So I have seen that happen too. But for care providers, it's not going to be a long-term permanent option. So tribal engagement. So I talked about that a bit before, and I'm going to harp on it a little bit more. I think as child advocates that we have this great soapbox we can stand on. And it's a soapbox that says, I need to know all about this child. I want to be the best advocate I can be. And please help me, tribe, to do a better job, to understand more about the tribe, to understand more about the family, to be able to provide good information to the court. So as I mentioned before, please always send your reports to the tribal representative and bring that phone number. I may say this 2 or 3 times during this presentation. I apologize for that, but bring that contact information with you all every time you can, because you can be the connection point for the child's tribe and relatives with the court and with the other participants. And then please, I know our court goes through and we do introductions before each hearing so we can put our appearances on the record. And I think that that's also an opportunity for the child advocate to say, oh, and we have Miss Billy Smith here, who's representing the Grand Ronde Nation, something like that, just to make sure that the court knows they're there, and then they can put their appearance on the record, because it's not always apparent when you're dealing with Zoom who all the participants are, and it might be a call in from a phone number, and then you don't have any idea. So if you can make it a point to remind the court to check. I'm sure that that Laura Lee addressed this yesterday, but when we're dealing with tribal cases, the tribes, the relatives, the extended family, they're the experts on the family and the culture. They're the people to go to find out more about child rearing practices, about helping the child make connections with their Native American culture. It's really important that children establish good foundations. For those of us that have been parents or have been relatives and watched children grow, we know how at a certain point, they're very small, they're very much trying to figure out who everybody is, and who's my cousin, and who's your mommy mom, or who's daddy's mommy, and is that daddy's mommy's sister? I can remember my kids asking these complicated questions, trying to sort out who these relatives were at family events. So it's important for children to get exposed to their extended family and to understand who their relatives are and who their tribal connections are. I think that now I'm going to turn it over to Kaycee to talk more about using the law and the guardian ad litem rules.
Thanks, Lori. So we're just going to go a little more into how you can use what you've learned about how the law works and what it's set up to do to advocate for kids on cases that you actually have. So we've talked about this INRAE ZJG, which is very hard for me to say, a couple of times. So it's been around for about a year and things are going to continue to change and develop. But as of now, the important things to remember about if this case is applying, if you hear that at that initial hearing or any subsequent hearing that the reason to know applies, you want to be following on your case to just make sure that the Indian Child Welfare Act's standards of that active efforts are being followed while it's being investigated on whether or not the Indian Child Welfare Act will apply for the remainder of the case. There's going to be a waiting period while we wait to hear back from tribes on whether or not the family will qualify for enrollment or is already enrolled. So keeping an eye on that is really important. We also want to make sure you're continuing to follow up with the family and saying, hey, do we have any heritage? Is there a reason to know that the Indian Child Welfare Act might apply to these children? Because what this case says is that any participant, and that includes the guardian ad litem and the child advocate, can bring that forward and say, I've talked to great aunt and they said that there could be some Indian heritage for this family. We need to look into that. And making sure that that we're keeping it in front of the court and at each hearing we're having that inquiry. If the reason to know standard has already been found, where are we at in tracking down those tribes? What notices have been provided? Making sure that that isn't forgotten before the court. Also have Commissioner Ressa from Spokane, who will be talking a little bit more about this as well in a later session. So hopefully she'll have some more perspective from a judicial viewpoint on what they're looking for as well. All right, so now we get to talk about like RCW and law numbers and things. Aren't you excited? I'm excited. So there are definitely laws and rules that apply to what you do as a guardian ad litem or a child advocate, and 1334 is dependency law. So your duty under that law, under 1D, is to report to the court about that child's legal status and their membership in a tribe, of Indian tribe or band. And under 1H, you're looking at if you have that child that is a member or eligible to enroll, knowing, understanding, and advocating for the best interest of that child. And that goes back to what Lori mentioned earlier with talking to their tribal representative, talking to their families and saying, help me understand more so that I can be the best advocate for this child that I can be. All right, so now we have 1338, that's our ICWA or Washington ICWA. So we're looking at that best interest of the Indian child. So we're looking at those practices that are also in accordance with the federal ICWA, that and other applicable laws here, which would be our dependency laws that are designed to accomplish these following things. All right, so we are looking to protect that safety, well-being, development, and stability of the Indian child. Preventing unnecessary out-of-home placements. So looking at getting those services in before we need to remove whenever possible. Acknowledging their right for the tribe to maintain their own existence by keeping their children connected to them. Recognizing and valuing the Indian child and establishing, developing, and maintaining their political, cultural, social, and spiritual relationship with their tribe and tribal community, including their extended family. And this is especially important when we have kids who are living in areas where they're not able to be directly connected to their tribe in their local area. It may need to be something like Zoom or phone calls to help them get connected to that tribal culture that they may not be enveloped in their local area. And then in proceedings under this chapter, which is our ICWA, where you have to have the out-of-home placement, remembering those placement priorities and that they're different from a case where ICWA does not apply, and making sure that those placement preferences are followed. And if you see that a child's not being placed in those placement preferences as they should be, bringing that up in court and saying, there's a Native family locally who wants to have placement with this child. Why are we not looking into that placement option? Being that squeaky wheel for that kid, because we want to make sure we're following what's best for them. So we have GALRs, which are guardian ad litem rules. So under guardian ad litem rule 2G, you have to make those reasonable efforts to contact all parties involved in the case. And as Lori mentioned earlier, the tribe may or may not be a legal party at the beginning of the case, but they can choose to intervene legally at any time. So the best practice is to reach out to their tribe, even if they have not legally intervened to become a party to the case yet, because they can provide all types of support. They can give tribal perspective to you, to that child who may not have that information or connection yet. You can get that child into contact with local elders or relatives. We can get educational materials that we can then pass on to that child or their placement if they're not able to be locally placed with someone from their own tribe. And there can also be tribal events that child can participate in, either with a local tribe or their own tribe, depending on the area where they're living.
One thing I wanted to point out too is that it's important for you to, in your discussions with the tribe, to get a sense of some of their suggestions for cultural activities, because a coastal tribe will not have the same traditions that you would have as an inland tribe. So going to a powwow, which is, you know, events that happen in many communities across the state of Washington, may not fit with some of the cultural traditions you might have, say, with the Makah or some of the other tribal communities. And that's something to consider and seek some guidance from the tribe on.
Absolutely. And that's where our world of technology can be a huge benefit, where a child may not be able to participate in person, but they at least may be able to witness a ceremony or be participating in it in a virtual format. So where are we at here? We are looking at the ability to ask for an interim or early review to monitor specific issues. So remember, you can always ask for that as the child's advocate. If you've tried to come to an understanding outside of court and you're just not getting anywhere, you can ask for an early review to bring your concerns before the court. Part of your role is to make sure the court is timely informed of what's happening in the case, and that's especially important in an ICWA case. So you can ask about if that notice has been provided, if we have received responses. The court can't force the tribe to respond, but at least we can make sure it's being talked about. Talking about whether or not that placement preference is being followed, that's really important. If we have a placement preference issue and as the child's advocate, you've been able to find a placement that is higher up in that hierarchy, it's important to bring that forward. And any other concerns you might have that have to do with the Indian Child Welfare Act, those can be brought up in court as well if necessary.
So Kaycee made a good point. It's like sometimes the tribes may not have responded. So one little anecdote I heard over the summer was that because of, as unintended consequences of ZJG, the state of Washington is inundating many tribal registration offices with requests for Indian child welfare information about children and families to see if ICWA does apply. And you know, some offices may have one person and suddenly they're dealing with hundreds and hundreds of inquiries and they don't have the capacity to catch up. So we need to be patient and understand that sometimes the things that happen in court in Seattle can really affect things that happen, you know, far, far away, you know, thousands of miles away in another state with another governmental entity trying to catch up.
Exactly. So making sure it's being brought up, even if it's been 2 months, 3 months, 4 months, just saying, you know, we're still waiting on that, but the notice has been sent and it has been received. So what else can you do to monitor ICWA and make sure it's being properly applied? You can ask for a shared planning meeting as an advocate. You do not have to wait for the social worker to call that meeting. You can ask for one and say, hey, I have a concern that I think we need to talk about. You can also ask for LICWAC staffing, especially when we have these cases now with reason to know we're not sure if ICWA is going to apply. LICWAC can be brought in to give tribal input, to give cultural input for these families as we're waiting to find out if the Indian Child Welfare Act will apply, and whether it, and when it does, generally that LICWAC staffings, those will stop, so that the child's tribe that they belong to will be involved in the case. And LICWAC and NAIR will both be talked about at a later session. So we're just letting you know that it exists, and you'll learn more about what they do later.
So Kaycee, what does LICWAC stand for?
Oh, you're gonna put me on the spot and make me remember. I always forget the last one. Local Indian Child Welfare Advisory Council.
Committee.
Council or committee?
Committee.
Yeah.
Committee.
Yeah.
I always get that one mixed up.
And do you remember what NAIR stands for?
Well, that one's there for me. The Native American Inquiry Referral.
Ah,
Very important
okay.
unit though. They do good work. All right, so we are going to, I believe after this, we're going to do our scenario. Yes? Am I getting ahead of myself? No.
You're getting ahead of yourself. So
No, I'm
we wanted to, we're repeating because we, somewhere along the line, Kaycee and I were trained that you need to repeat things for people to actually absorb them. So we're trying to repeat them in an interesting and informative manner.
We are repeating, but we are asking you to keep these in mind because we will be having you do a scenario very soon. So think about these things while you're reading through it, and we're going to give you some time to discuss in small groups. So think about these things as you're reading our scenario in just a couple minutes. So remember that ICWA only applies in state courts. If the tribe takes jurisdiction, they have their own laws that they follow, and ICWA is not applied. And it is based on that political affiliation. I saw in the chat earlier, someone was concerned about challenges to ICWA on a national level. And one of those challenges is currently that it is a law based on a racial standard and not a political standard. I would argue that that's not true very vehemently. It is based on political status and membership in a tribe, not a ethnic or racial heritage. So do keep that in mind. Oh, we've lost our list.
How did that happen?
That's okay, I've got a note. So the tribe decides, because they are their own nation, they have their own laws, they decide who can be a member and who is not able to be a member. Those placement preferences that change, the tribe can change that level. They can help decide what those look like. And they also get to decide whether or not to take jurisdiction. And as Lori mentioned, there are some tribes who just don't have the capacity to take jurisdiction. Some of them don't even have the capacity to legally intervene, which is why best practice is to just make sure you're maintaining contact with the tribe as much as you can. And be proactive. Inquire about that Native ancestry. Keep asking. Ask if you have families that say, I don't know, say, do you have any other family members who we can talk to who might have more information? Be persistent.
And now we're going to do breakout rooms. Ryan will provide us guidance on how that's going to happen and how that's going to work. I think the PDF is going to go in the chat. There's a link.
I'm doing that right now.
Kaycee's going to do that. And it's a scenario that shouldn't take you too long to read through. And we're asking you, when you'll get assigned to breakout rooms, go to the breakout room. And then the idea is to discuss the scenario. And Ryan's going to explain, there are different questions that go with a scenario. And each breakout room is going to discuss a specific question. And I'm going to turn it over to, oh, Jenny raised her hand. What's the question?
Hi, I tried to access the document and it says I needed to request access. So I'm not sure if that will come up for everybody.
Maybe Ryan can fix this. It would be very boring if we read this out loud.
Yeah, I didn't have that problem last time, so I'm not sure what's happening.
Yeah, I'm getting that same thing. I just opened the same scenarios. I dropped the file. So there should be a Word document. So you should be able to open that one up. It's the same thing.
Thank you, Ryan.
Okay. And so I'll turn it over to Ryan, and then Kaycee and I may drop into the chat rooms.
Absolutely. So what I've done is there are going to be 10 breakout rooms. And so each one of the groups will be discussing one of the questions at the end of the scenario. There's 5 discussion questions. So groups 1 and 6 will discuss question 1. Groups 2 and 7 will discuss question 2. Groups 3 and, oh my gosh, this is like doing birthday things. Thank you. 5, 6, 8. We'll work on discussion question 3. Groups 4 and 9 will work on discussion question 4, and groups 5 and 10 will work on the last discussion question 5. I know that sounds super complicated, but just if you're in group 6, 7, 8, or 9, just pick a question, right? If you can't figure out, or if you couldn't follow my logic. Laura, I know that's going to drive the attorneys crazy because they're all very logic driven and they want, everything put into little buckets, but
it makes perfect sense, Ryan. Absolutely. You just start over with number 1 if you're 6 and go down the line.
I said just talk about questions. You'll be fine.
It'll be great. And then we'll come back and we'll have a little discussion and go ahead and have fun.
How long did you want to, are we still on schedule, 12 minutes?
We were thinking like 8 or 9 minutes in the discussion.
8 or 9? So pick.
Yeah.
All right, we'll say 8 minutes. All right, I'm going to open the rooms now, everyone.
And we're going to go through some discussion questions. So which groups had scenario number, had the question number 1?
Yes.
Yeah.
Okay. So that was our question. Okay. We answered all of them, but that's okay.
Oh, because you're A students.
That's right. Brownie
I had a
points.
good group so we stated that yes, there is reason to know.
Okay, and why did you say that there was reason to know?
Because it was self-reported.
And
So
what
that-
about the Canadian First Nations? What did that do?
Help me out, Lori.
Well,
Well, in the
Canadian-
scenario,
yeah, the Canadians First Nation is not under the ICWA law at this time. So, I mean, the child can be considered Indian, but not under our law in the state or the United States.
Okay. That's good to know. I think we were reading it as a whole because I had to read it out loud. So we were thinking, well, they're reporting ancestry, native ancestry. And so there is reason to know.
so the Indian Child Welfare Act applies to federally recognized tribes in the United States. So tribes that are outside the United States are not United States tribes. And so the Indian Child Welfare Act does not apply to them. So when you get a Canadians First Nations tribal member, while they have cultural history and indigenous issues that are maybe very similar to that facing tribes in the United States, the Indian Child Welfare Act does not apply to them. And if you look into your history, as Laura alluded to yesterday, there were many similar governmental atrocities against First Nations people in Canada as there were against Native Americans and Alaska Natives in the United States. The reason I asked about that First Nations is because it's kind of a trick question, because you might think, oh, well, then it doesn't apply and we don't have to consider that. But I think later on in this scenario, we find out a little bit more about the mom. Jenny, you have your hand up. What's your question?
I do, yeah. Do any tribes in Washington have interest in children that have First Native heritage? I would just think that there might be. I understand the legal aspect of it, but wanting to teach the heritage or have connections with them, or I mean, we're not that far away, right? Like
Well, if you look at the map of Washington, and you'll notice that all the tribes that are along the northern border of the United States, it's an artificial border along one of the parallels that has nothing to do with cultural connections or anything. So there are lots of issues about tribal members going back and forth and fishing and hunting rights, and really some really interesting stuff that's gone on in courts in the United States as well as courts in provinces in BC and other parts of Canada. And certainly this, the Salish Sea that goes up Puget Sound, that goes up north and around Vancouver Island and stuff, all of those, they're familial groups that are connected in through there. So, if the child is a member of a First Nations group, it may be culturally appropriate to try to find a placement in a Native American home with similar traditions as that child, if that's possible.
And
but
that's
ICWA doesn't apply.
It was just something you would advocate for and maybe just ask some questions about and try to, I don't know.
Mm-hmm.
Okay.
Just like if a child is from an immigrant community, it may make sense to support that child's connection with that community while they're waiting to be reunified with their parents or extended family. Okay, so that was question number 1. Anybody have any questions about this reason to know? You guys all found that ICWA applied. Okay, let's see if I can get, let's see, here we have some answers. At the initial shelter care, David indicated he has a connection to a federally recognized Indian tribe. So that was the Ketchikan tribe. And then, he doesn't have to show his membership card or any other official document. He just has to say that, yes, I'm connected to the tribe. I have tribal ancestry. And then ZJG applies. And then once the reason to know applies, then the state is required to send out notices and do the genealogy chart. They should do that on all their cases anyway. And the protections of ICWA apply. This is still being worked out. I mean, we've only had this case has only been in effect for about a year now. And there are a lot of things in it we don't quite understand. And it will be really interesting. The Judge Montoya Lewis, Justice Montoya Lewis authored the decision in In Re ZJG, and it has a lot of depth to it. It's very complicated. So I would expect that we will not really understand the true implications for years. So question number 2, Kaycee.
All right, so we already kind of talked about this a little. Did anyone have any questions about how we know whether or not those kids are Indian children and if they fall under the Indian Child Welfare Act? I'm getting silent, so let's just go on because we're running a little short on time. We've only got 5 minutes left. So, of course, all of the children are Indian children, as we talked about before. It's about their culture and their heritage, but the Indian Child Welfare Act at this point only applies to Stuart, Laura, and Emma because they are the children of the enrolled member in the Ketchikan Indian community, and they are eligible to enroll. Alex is not protected under ICWA right now because he's not the child of an enrolled member of a federally recognized tribe and is not enrolled himself. And then Lori had also brought up that First Nation heritage. So remembering that culturally that it's not unimportant. It is a very important part of who he is, but it does not make the law apply to him. So the Canadian First Nation tribe just isn't included at this time.
Okay, so if ICWA applies, does the active effort standard apply to this case going forward? Did it apply before the case was filed? Anybody want to respond to that?
Yes, I believe it is. The active effort standard does apply. And no, I don't think it was being met, and didn't see a lot of efforts being made by the state for, in this case.
So the facts have this little tidbit in there about a extended family member named Ellen, who's part of the Coeur d'Alene tribe. And then it's so like nobody investigated her. Here is a person that is connected, extended family, and nobody investigated whether she might be placed in. And did they provide any services to try to ameliorate the situations in the home? I didn't see any of that either. So here we go. Active efforts absolutely apply, and it applies to those three younger, and ICWA is going to apply to Alex in the future. I think we saw, because mom decided that figured out that her mother had connections with the Coeur d'Alene tribe. And it has to be simply beyond referring. Active efforts are those things like driving somebody to appointments, sitting down with them and helping them make calls to set things up. And I agree that it's not clear that this caseworker was meeting that standard. And when there was a complaint that the parenting class didn't meet their expectations, I think that's a dead giveaway. And Kaycee, number 4.
All right, so we have that placement preference, which we've talked about just a minute ago. I see a lot of questions popping up in the chat right now, and unfortunately, we're just not going to have time to get to them. But I think if you can, Ryan, I know you're going to have the chat log. Maybe you can get those to us, and we can try and get answers to you to send out to the group that's here for those questions we won't have time for. So we know that placement preference was not being followed because they did not look into that auntie who was requested by the parents to be a placement for the kids. Nobody even knew, the social worker didn't even know about her. So that's a huge concern. If you were that child advocate, you want to make sure that was being brought up.
Whoops. Okay, we already talked about that. Okay, number 5. Is the volunteer advocate responsible under ICWA or the JLRs to keep the Ketchikan Indian community informed as they've requested? If so, how can the volunteer meet that responsibility? Well, you all know this answer. What's the answer? You send them your reports, right? Yeah, you should get a copy of your report sent out. And I hope you all can do that on your cases from now on. It's a courtesy if they haven't intervened, but I think it's just so valuable, and it's respectful. It is respectful of the efforts that the tribes are making to keep in contact with their members, to keep their tribe and their culture alive, and then contact the tribal representative throughout the case. JLR requires reasonable efforts to contact all parties, and that includes the child's tribe. So that's something that the child advocate is supposed to do, to contact the child's tribe. And it's always best practice to keep in contact, even where intervention has not occurred. So I hope you guys will all look at and keep in mind these points. I don't know, are there 5 now? We had 4 at one point, but I said 5 at the top. So ICWA applies in state court. It's a sovereign to sovereign relationship. It's not ethnic. It's not racially. It's not by how you look. It's the citizenship thing. So remember, it's citizenship. The tribe gets to decide. If a tribe is involved and the child is a citizen, the tribe gets to decide, and they decide on membership. They have their placement preferences, and they decide whether they want to take jurisdiction. And then child advocates need to be proactive to inquire about Native ancestry, to keep the tribe informed, to inform yourself so that you're more knowledgeable. None of us is ever going to be an expert on the tribes we work with unless we're a member of the tribe. And many of us do not have that tribal connection. So we need to be humble and go in there with humbleness and inquiring minds to seek guidance from the people that do know. I want to thank you all for attending today. I just can't believe that we've now, Kaycee and I have completed our 5th ICWA legal presentation. It doesn't look like anybody fell asleep or dropped out loudly, maybe quietly, but we appreciate your attention because we know that the legal section can kind of be dense. It's not as exciting and robust as things like LICWAC and NAIR and Laura's presentation. But thank you so much for your attention. And I hope that you all will be strong advocates for our Native American and Alaska Native children in the future. Laura has kindly left her contact information, I think, on the chat. You can find me, I think, just if you Google me? I don't know. That's frightening.
Sorry, we'll get it to you.
Is there more? Is there another slide? Oh, there we go.
There you go.
Yeah. You can always find me at lori.irwin@kingcounty.gov. It's like, and send me questions, but your program staff are going to be your primary resource to get started as you continue your learning process. So thank you very much. And I'll turn it over to Laura and Kaycee if they have any additional words.
No, I just want to
reiterate, thank you, everyone. We appreciate your time. The law is not always exciting, but it's important to have those foundations so that you can learn from them and know who to ask the right questions of.
That's true. I just want to thank you, both of you, for once again having a great presentation, and I'm honored that you continue to be a part of this ICWA Institute, because you are valuable to this longstanding committee. So I appreciate you, and thank you everyone for being here. And tomorrow we'll have a perspective from the judicial side of things. So thank you, and until tomorrow.
And what time is that presentation tomorrow, Ryan?
2:30 or 2:30, just like today.
Is that correct? Great.
Yeah.
Thank you so much.
Here's
Thank you all. Have a nice evening.
Nice wave, Lori.
Elbow, elbow, wrist, wrist. Thank you.
There you go. Too fun. All right, y'all.